You here with us? There we go.
Yes, Your Honor. Good morning.
Okay. All right. Good morning, all. It's 9 a.m. Welcome to another session of oral argument by Zoom with the 5th DCA. We have 3 cases this morning at 9, 10, and 11, respectively. I am Judge Lambert. I'll be presiding over each of those cases. Joining me on the panel are Judges Harris and Judge Sasso. You can see them on the screen. Our first case is 20-1130. You'll see on the clock, because there's a cross appeal, I've allowed 25 minutes for each side. So I will reserve 5 minutes for Mr. Hauser for rebuttal. Unless you tell me you want some different amount of time. Keep in mind that we are being watched. Well, we are watchable. Whether anybody's watching us or not, I'm not sure, but we are on YouTube. So keep that in mind with any comments you make, that you are being recorded or observed. Also, if you have any type of electronic devices, please put those either on mute or on or turn them off so that you don't interrupt either the court or your opposing counsel during the argument. First case again is Jorge and Aurelia Colon versus Stillwater Property and Casualty Insurance Company. I apologize if I mispronounce anybody's name. So Mr. Hauser, if you are ready, go ahead, sir.
I am. I'm at home, and you may hear some barking in the background. I've done my best to stop my dog from barking, but I can't guarantee it. So I apologize. I would ask that Judge Lambert, you let me know when I have 10 minutes remaining for purposes of rebuttal. Your Honor, this is a very simple case. The final judgment in this case reduced the number of hours billed by Mr. Woodward, the attorney for the Colons, from 314 hours to 135 hours, a reduction of almost 60%. The final judgment is flawed and fatally defective on its face because the final judgment fails to state with specificity what specific hours the judge reduced and the reasons that they were reduced. This is fundamental error. I don't know if the court has had the opportunity to read the second DCA case of Lazardi versus Federated National, 322, Southern 3rd, 184. That case, have you had an opportunity to read that case? Oh, okay. That case was decided by the second DCA in June of 2021. I did send it out as supplemental authority. Unfortunately, from my perspective, it came out about a month after my reply brief. But in that particular case, the second DCA ruled that where a judge substantially reduces the number of hours, and in Lazardi, the hours were reduced from 330 hours to 200 hours, where the final judgment fails to state with specificity what hours were reduced and the reason for reduction. It was not just error, it was fundamental error.
Well, let me ask this. Is there some threshold? In other words, let's say in this case, hypothetically, that your client was asking for $1 million in attorney fees, and it's a 200-page bill. And the judge gets that, here's the evidence at the hearing, and says, I'm going to award much less. Is it your position that as a matter of law, that the judge has to go through every entry that he or she is reducing the requested fee and put that in the judgment?
The answer is yes, but it's not my allegation. It's what the other district courts of appeal.
Well, okay, let's not get semantical. I mean, that's your position today, is that judge, so all the judges, if a party moving for the attorney fees says, here's my bill, here's my hours, here's my hourly rate, and the opposing party contests that, if the judge wants to do something different after an evidentiary hearing than what is requesting by the moving party, he or she has to enter in the judgment saying, I find this number of hours and this is the hourly rate. And from the 500 or 1,000 or 2,000 hours, here's how I reduce on day one. Instead of 2 hours for preparing, 1 hour. That's what the position you're arguing based upon the case law that you've cited?
Yes, and let me explain why this sounds impossible.
That seems pretty onerous to me to tell every judge in every case.
Except, Your Honor, if in fact the losing party does what it's supposed to do, it does exactly that. In other words, in this particular case, the court ordered that Stillwater do a line-by-line analysis as to what objections it made. And that is part of what a court is required, that a party is required to do. Your Honor, the first, second, and fourth district court of appeals, there's a dozen cases. This isn't new. This isn't anything unique. And this wasn't $1 million in attorney's fees.
No, I know, but it's my hypothetical, and that's what we talk about when we have oral arguments.
Okay, sir, I didn't mean to be disrespectful. The first, second, and fourth district court of appeals, there's a dozen cases out there that have reversed the significant denial of attorney's fees or reduction of attorney's fees because the final judgment failed to state with specificity what the hours were that were reduced and the reason. And what's the reason for the reduction? The reason is simple, that how can you possibly be able to meaningfully review the reduction of attorney's fees unless you know what hours were reduced and the reason for the reduction. And that's the reasons for the reversal. As I said in Lizardi, there was no transcript of the hearing. In Lizardi, the number of hours was 311, it was 330 to 220, which is virtually identical to the case at bar. Of course, in our particular case, we do have a transcript of the hearing. The standard of review, because it's fundamental error, is de novo. The requirements of a final judgment, I don't need to cite the cases, do I, if you want me to? I mean, I can cite you all the cases that are reversed from the first DCA, second DCA, and fourth DCA, because the final judgments failed to state with specificity the basis for its reduction.
Well, one of the cases you cite for that proposition is Thorpe. Tell me how Thorpe applies.
I believe I made them in Thorpe. Let me take a look at my notes for a second. In Thorpe, I believe that was a guardianship case and was a guardian, but the analysis is still the same.
Well, how's the analysis the same? Guardian fees are very different than attorney fees, aren't they?
Well, no, they reduced the number of hours because they failed to specify the reason for the reduction. Let's assume for the sake of argument, we don't include Thorpe. Okay, we're now down to 11 cases. The first DCA.
When talk about Puleo, tell me how Puleo helps you.
What?
You say Puleo reversed the trial court for failing to identify specific entries that deducted. Where does Puleo say that?
All right, let me go back to my notes.
The judge there simply failed to make the findings of a reasonable hourly rate and reasonable number of hours expended.
But what the court also said is, and I'm not questioning the time you put in, I'm not questioning your rate. It's reasonable. I think with litigation, 3 volumes, court files, that's what I think is reasonable. And this is what the second DCA said. A trial court may reduce attorney fees that it determines to be excessive if it makes the required findings to support that determination. So
which is number of hours and hourly rate, right?
No. If you're gonna reduce the number of hours, how can you meaningfully review the number of hours reduced by this trial court without knowing what those hours are? And the answer is you cannot. And that's exactly what the second DCA said in Lizardi. In Lizardi, he put in the reasonable number of hours. He put in the reasonable hourly rate, but he failed to state with specificity what those hours are. Again, Lizardi is 322, Southern 3rd, 184. Your Honor, the first DCA in Fleming v. Fleming, 279, Southern 3rd, 763. A recent case just came down on November 10th, Wattrell versus Wattrell, 2021 Florida Appeal Lexus 214681. In that particular case, it was a divorce case. The trial court reduced the award of the fee by 50%, but it failed to state with specificity the reason why it did that. The second DCA has a half a dozen cases where attorney's fees have been reduced, and the second DCA has reversed. I think both the case of Foreman v. Foreman, 288 Southern 3rd, 697. This is from the 4th DCA. The court stated at 698, although the court reduced the amount of attorney's fees sought on this basis, that some of the billing entries were duplicative, the court did not specify which entries were duplicative. And in Parton versus Palomino Lakes, another case from the 2nd, the court reduced the requested fees by 25%, stating that the efforts of plaintiff's attorney, as reflected in the time records, seemed somewhat inflated, similar to the case of Barr. Although a trial court
has the Florida Supreme Court weighed in on this with the specificity requirement that you're saying that the 1st, 2nd, and 4th require?
No, and I hope they don't have to based after this case, but no, they have not yet ruled on this. But if I could finish my quote, although the trial court felt the fees were excessive on remand, it must make the required findings to support the determination of the amount of reasonable attorney's fees. This is a question of evidence. Simple. So Stillwater has to sustain its burden of proof to prove that Mr. Woodward was not entitled to the reasonable fees as testified to by plaintiff's expert witness.
Isn't it the move-in's burden to establish that the fees are reasonable? Isn't that what the case law tells us?
Yes, we have to establish that the fees are reasonable. The defense has to establish with specificity what hours are not reasonable.
What's your best argument? You've I think recognized that the Florida Supreme Court has not adopted the specificity argument that you're advocating for. We are obviously in the 5th DCA not bound by the 1st, 2nd, 3rd, or 4th. What is your best argument for why this court in this case should write an opinion saying that trial courts are required to go line by line through a moving party's attorney's fees and in their order specify specifically which items they're deducting and why?
Well, the best argument is how can you possibly review this case without being able to do a line-by-line analysis? You can't. You don't know what hours he reduced.
But we've done it in the 5th DCA.
I'm sorry, what?
In the 5th DCA, we've never required this before. So we've been functioning under the idea that assuming that the trial court's order specifies its determination under Roe, which it did here, it says, again, I'm clarifying that I'm not saying that he didn't do the work. I'm saying that these were the hours reasonably expended based on the testimony I've heard.
Okay.
And so why giving the trial court the deference that we're required to give, is that not sufficient to demonstrate that the fees are reasonable here?
It's because you cannot meaningfully review the court's reduction of hours. Remember, in this case, the expert for the plaintiff said 253 hours was reasonable. The expert for the defendant said 165 hours was reasonable. The judge reduced it even more to 135 hours. So we have no idea why he did it and what basis it was. As I said,
so is the judge required to pick one or the other, or is it your concern it's below even the lowest amount testified? In other words, if the judge said, I think 200 hours is reasonable, would that be his or her discretion?
If the judge said 230 hours, I'm not sure that would be a significant reduction. But if the judge is reducing this by 60% or 65%, that's a significant reduction. And if I could just have about 2 minutes, the defense, the losing party, has the burden of showing to the court what hours it thought were unreasonable. It failed in that burden regarding its expert witness. Its expert witness, Mr. Rock, testified in general terms that he thought that the amount of hours spent by plaintiff's counsel was excessive. However, that isn't sufficient. Their burden of proof, and that's what this is about, their burden of proof is to show with specificity which hours were excessive. And I'm quoting from the 4th DCA, 22nd Century Properties versus FPH. In this case, Eplamp cites 11 examples of double billing and excessiveness. Notably absent from the appellant's string of examples are record citations. Few of these asserted billing discrepancies were contested at the trial level. In this case, Mr. Rock, I think, prepared a line-by-line analysis. But for whatever reason, Stillwater never introduced that document into evidence.
Why aren't these arguments relevant to evidentiary weight? In other words, the trial court heard somebody testify in general terms. Some trial courts might have said that's too general. I'm not going to accept that testimony. This trial court apparently did accept that testimony. Why is this not a matter of weight that trial courts it is within their province to determine the weight of the testimony that they're going to accept, as opposed to what it seems like you're requiring, which is a new procedural rule? In every attorney's fees case, we need line by line description of what you've done and why you've done it. Then we need a line by line dispute about why that's inappropriate. And then the trial court needs to go line by line and address which testimony is more compelling. So are you really advocating for a new procedural rule, or is this not a matter of weight?
It's not, they have the obligation of showing with specificity what hours were excessive. Now, Mr. Angel did an extensive cross-examination of Mr. Woodward. That's in the record. But what's not in the record, what's not as part of the evidence is Mr. Rock's testimony. They didn't sustain their burden of proof. That's what this case rises and falls under. They didn't sustain their burden of proof. This isn't unusual. I mean, all the other district courts of appeal, you have to state with specificity what the hours are, or you can't meaningfully have appellate review.
Can't the judge make the finding on reasonableness based on his own experience and his own knowledge and familiarity with this type of litigation?
No.
Isn't that a factor?
No.
He has to just accept one of the experts?
The fact is, in case law, where courts have reduced the hourly rate from 325 to 200 based on the court's knowledge, and it's been reversed.
The court has to make the finding of reasonableness. And the court found that the hours that you submitted were not reasonable. Why doesn't that mean you failed to sustain your burden of proof?
That's the whole point, Your Honor. The whole point is that if you look at the record, if you look at what Mr. Danahy, the expert for the plaintiff, testified to, he went into a line-by-line analysis that was introduced into evidence as exhibit number 8. He did a line-by-line analysis. He reduced the number of hours by 60 hours, which was a 20% reduction. Remember, Your Honor, this attorney's fees were awarded under Florida Statute 627-428. Under that statute, the insured is entitled to attorney's fees, but the insurance company is not. And Your Honor, on that basis, how in God's name can Mr. Colognes play on a level playing field with Stillwater when Stillwater billed 246 hours and the court is only allowing 135 hours?
All right, Mr. Hauser, you're about 9 minutes. Do you want to keep going, or?
I want to stop.
Okay. All right. Very well. All right. You have 8:49 in rebuttal.
Thank you, sir.
All right. Is it Angel?
Yes, Your Honor, and may it please the court, my name is Derek Angel. I represent Stillwater in this attorney's fees appeal. And this is a record that I think, before we get into the weeds, as we just heard with the case law and what may be required, this is a record that we have to take a step back from. We have a routine first-party property case with a pre-suit demand of around $88,000 that later settled for 35 or 38 grand, where the lawyer can then come in a fee hearing with a straight face, ask for over $250,000 in attorney's fees. And that should give everyone pause for the same reasons the Supreme Court said 85 years ago in that Barrich case, the significance of what the attorney fee does to the ability of the court to administer justice. You know, it's lost sometimes that a case like this, Stillwater being an insurance company, you know, they're made up people, and the adjusters, the supervisors that look at these files.
What's your best legal argument for reversal?
For what, Your Honor? I missed that.
Yeah, what's your best legal argument?
On the affirmance of what we just heard, I think we heard, before I get to the cross appeal, if that's all right, I think that in this case, it's apparent, it certainly was to me, and I think it was to everybody else in that room, that Judge Murphy did his level best to do the impossible, which is to figure out exactly how many reasonable hours were spent here. And I think if there's a case that this court should follow, it is the Supreme Court, the U.S. Supreme Court, in the Fox versus Vice case from 2011, which, as far as I can tell, has not been cited by a Florida case, where Justice Kagan recognized that the task of divining attorney's fees is rough justice. You're trying to do the best you can with something that's impossible, right? I mean, my value as an attorney is different to my client, whether I'm arguing to a DCA or defending a non-party witness deposition or writing a motion, but we do the best we can by coming up with hourly rates and we figure out reasonable time, and that's what we do. It's not a job, as again, to quote Her Honor, that this is not a job for green eye shade accountants. This is not auditing perfection that we seek. And I think the Supreme Court had figured that out and understands that. And Judge Murphy absolutely did his honor's level best in figuring out what to do here. And what do
Let's
you
try this at a different route then. If we think the first, second, and fourth positions as espoused by Mr. Hauser, or argued by Mr. Hauser, is the way to go here, is there error then on the face of the final judgment?
Well, first of all, I'm not sure that Mr. Hauser's interpretation is correct. I don't know that any of those cases require a true line item audit of all the timesheets, but they do require, I think, more specificity, conceitedly, than perhaps we have in this order. But I think,
all right, let me rephrase it again then. If I read the cases that Mr. Hauser cites, that basically some of our sister courts think that if the party that opposes the request for the fees wants to have it, wants to get a reduced award, they have to put on evidence to show why that requested fee is excessive, and that the trial court, if the trial court does not grant the requested fees testified to by the movant, he or she has to itemize and explain why they've reduced the amount. If that's how those cases are read, and if we agree with those positions, then isn't your position on the main appeal problematic?
no, Your Honor, and I'll tell you, the reason is because we did do that line item analysis. It is in the record. It was provided to the
The
court.
trial judge, all right, try it again. The trial judge have to put it in the final judgment? That seems.
I just don't possibly see that. I don't read again, I just don't see the cases that way. And I think that's an impossible burden to place on a trial judge, as Your Honor noted. If you do have a 2,000 line item case, and this one, there was 15 pages of 10-point font, right? Then we already spent 7 hours in front of the court in this case. That's over 2 days. We were asking to have a week-long trial of every time a fee, and this didn't involve a jury trial, right? Imagine how many hours there are. So I think the requirements of Roe and even of the other cases say you must provide the hourly rate, you must provide the reasonable hours, and you must, if you're going to reduce it, say why. And His Honor did that. It may not be it wasn't an encyclopedic sort of recitation of why he did that, but he said why. In fact, on rehearing, he clarified even farther why he did what he did. But I will tell you what I think happened. And I think reading between the very clear lines in this case is that His Honor just didn't believe the timesheets. And if what they're asking for is that the judge must say, I don't believe this. Think about what precedent we're setting here. We're not talking about the reasonable fee for a doctor or an engineer. We're talking about attorneys, an attorney who now has become the witness, who's now biased and whose proclivities are on trial for the judge to determine his credibility. It's a very unpleasant and unfortunate sort of procedure.
Trial judges have to do that all the time. When there's peremptory challenges being exercised and a Melbourne issue is raised, the judge has to decide whether it's pretextual. I mean, and that's basically saying that, you, Mr. or Ms. Lawyer, are not giving me the real reason why you want to strike somebody. So I think trial judges, especially those who've been most, you have the backbone to make that call. It's not as egregious as you're making it sound that you have to do it sometimes. So,
well, I do think that's what His Honor did, and I'm not one to use props in oral argument, but every time I go through this record and I find something new, and I did cite this, but just for example here, and I put this and I called this out, and certainly had it in our pre-hearing line item review on 1828 in the record. I know Mr. Rock had it in his annotation, which is in the record at 2228. But this is a motion here that was drafted by a 1 or 2 year lawyer, Nick Mari, an associate of ours, and he spent 0.5 drafting this motion. This is it. This 0.5. It just says this case is set for trial. We sent interrogatories. We sent arrest reduction. We followed up. There's been no response. That's what this says. And Mr. Woodward billed a 0.8 for reviewing that. Does anybody believe that? And that we are here for 50 minutes on the clock, Your Honor. That's a 0.8. Do we think that somebody could look at this motion for the entire time that we are here for argument? And I think the judge, and of course, I did cross-examine Mr. Woodward on this and numerous other examples in this record. The judge did his job. He weighed the credibility and said, I just don't believe this. Now, did he put that in there? No, and I think that was, if nothing else, a professional thing for his honor to do, because again, we're dealing with lawyers. You don't want to author something for somebody that you're going to see again before he was an advocate.
Do you acknowledge that Mr. Hauser's argument to that, let's use your example here, is that if the trial judge did not think 0.8 hours was reasonable for that entry in the overall process of reducing the requested amount of fees, that the judge would then have to say, I think that 0.2 hours would have been reasonable as opposed to 0.8 for that event?
Again,
I'm not saying whether you agree that you like it. Let's not get off on the morality of all this again. That's Mr. Hauser's argument, though.
I understand that's the argument.
And that's what he says that the first, second, and fourth are requiring. Do you agree that that's what he's arguing, not whether you like it or not?
I agree that's what he's arguing.
Okay. And if that's how the first, second, and fourth cases are to be read, then that would be problematic here for your situation. Not that, well, the judge did a great job. He listened to all this. He didn't make the specific findings to reduce it, if that's the position that we ultimately take here.
If that is the onerous standard that's going to be inflicted on our trial judges, then Your Honor,
whether we refer to it as onerous or not, if that's the standard we think, then that's what the rub of the whole case is.
I agree. Now, though there is a catch there, which is that, as Judge Sasso pointed out, it is in fact the plaintiff's burden to, in the first instance, to prove the reasonableness. And I do think it's within the judge's discretion. I don't think the cases say that he must do this. He can just reject that the burden's been carried as to certain hours. I don't know that the cases say that he must specify that. I think it's more about the reduction side. But this is getting very technical, and it's all court made, which again, I think is why we take a step back and look at what's really going on here. I mean, His Honor had the impossible task where you had experts who took the time written down at its face. Both of them, I was very clear to have them say that in that hearing, that if it was a 0.8 written down, they assumed it was done. And His Honor was the only one in that room that didn't have to do that. So I would suggest that he did not find that they'd carried their burden, and that these cases, to the extent they say what Mr. Hauser thinks they say, don't require that sort of itemization. So if there's any other questions on the main appeal, I'd like to move to the cross appeal at this time, because I did raise several issues, and the first of which is the hourly rate. And this is a practice that I've seen since I was, the first time I handled one of these cases or was at a fee hearing, that flabbergasted me then, it flabbergasted me now. The rule in Roe is we must show what the market will support for a lawyer. The evidence of that can come in many forms. What other lawyers charge, but what other lawyers charge is the key. And I had a nice little exchange with Mr. Danahy, who would not agree what the word charge meant. He said that's a nebulous term. I don't think it's nebulous at all. And the practice has become so commonplace. What we do is these plaintiffs.
Why is this evidence in the affidavit not enough? It's at record 482. Mr. Woodward's claim rate of $450 is in the range of reasonable rates charged by similar attorneys who specialize. It says charged by.
And is that, without having that right in front of me, is that Mr. Danahy's affidavit?
I can't recall, but if we're looking at the rate that was awarded, and we have testimony that they usually command rates of $450 to $600. The rate that is usually charged is $450. If we have information on this range, it's not just awards. Why is that not competent substantial evidence of the fee award in this case?
Because on cross-examination, and this does not go to weight or credibility, on cross-examination, Mr. Danahy was clear that that number was derived from two sources. One, what his plaintiff contingency friends told him that they think they're worth, and two, what other judges award contingent plaintiff lawyers, not what anybody actually charges a paying client. And as I was saying, so that evidence is not actually evidence at all. It is not what the market charges or what will be supported by the economic market. The line that comes from Judge Moxley is that the courtroom is not the marketplace. What a judge awards a lawyer in case A does not mean that that is what the market would support. And
Who's
so
Judge Moxley? Who's that?
He's a retired judge from Brevard, I believe. And
okay.
You may recall, I just remember I was at a fee hearing. It was with the Pagic firm after a case that went to the Supreme Court and back, Bowen versus Christensen. And they did in that hearing, this is all outside the record, of course, but since Your Honor asked, they did what we did here. We have the plaintiffs come in with all these orders of what judges award plaintiffs attorneys. And he said, look, that's not competent substantial evidence. And he awarded.
Your expert said $400 was the reasonable rate, right?
I agree. That's what he said.
Okay. And so you'd be stuck with that, wouldn't you?
Well, under the Deshpandy case from last year, I believe it was last year, I don't think so. I think that actually the fourth TCA said was if you don't carry your burden and you've had your opportunity, you get nothing. But in that case, they did what I suggested in the brief, which is that's a little too harsh. So what the fourth DCA said, okay, we'll give those plaintiff lawyers, we'll give what the defense expert said. And that's what I recommended in the brief, which would be the 400 number. So I don't think as a technical legal matter, we are stuck with it. I think if the plaintiff rests their case without putting on any evidence of what the market would actually support, and all they did was introduce hourly rates from other lawyers, I think we could reverse the entire award. I think that would be a possible legal outcome. But the point is, though, is that those orders of what other judges award it's hearsay and it's irrelevant. And I argue that over and over again at the fee hearing, and I continue to believe that. And every time I've seen one of these hearings, when we look at these fee orders, one of them was reverse engineered by Mr. Woodward that worked out to be exactly $20,000. It said he was worth $500 an hour. But if you look at that order, and I did the math in the brief, what happened there? He settled the underlying case and then settled the fee claim for 20 grand. Then he backs in a way to get hours at $500 an hour when then you tack on costs to the penny to get to right at $20,000. He takes that order that says $500, he hands it to his fee expert, who then says, Mr. Woodward worth $500. Look what this judge said. So the way to introduce this evidence properly, in my opinion, is to find other lawyers to come and say, I charge A, B, C, D, whatever, and I do similar work. It doesn't have to be precisely the same thing of contingent first party property work. And then look to see what the market supports. Pretty simple. But none of that happened here. It doesn't happen in any of these cases. So I do think that the way that we find what reasonable hours is fundamentally flawed in every hearing that I've been in with these things. In any event, that's the first point. The second point is, of course, the multiplier, which I'm partially to blame for the Joyce case that I was somewhat hoping I'd have Judge Cohen on this panel because we argued Joyce. He was
I
very
was on that panel.
Well, I remember Judge Lambert, Judge Cohen took the lead, if you will, and he was very vocal
Probably
in that.
primary. I don't know.
But in any event, that case, I think we all saw what it was, right? And which was that the market did not require a multiplier then. And I remember when the Supreme Court, the day they granted the petition to review it,
if we operate under our existing case law, obviously we can't recede from Florida Supreme Court precedent. I think if I understand your argument, that we would still be able to reverse because the only testimony is about first property insurance cases in general, not specific to this case, would require the use of a multiplier. In other words, if we uphold the trial court's decision to use a multiplier in this case, it would be every case because the testimony was so general. Is that an accurate characterization of your argument?
I think so. I do think it does still require a case-by-case analysis, and I think this case has absolutely nothing that makes it stand out from any other first-party property case. Your Honor.
This is my question in that regard as to whether this case stands out. The testimony was that that this is a veteran with language issues and PTSD, and there was already a EUO set, and there's what was characterized as potential spoliation issues because we have these other assignment of benefit claims that are out there and these various motions to consolidate. If the trial court accepted that testimony as particular to this case, why would that not be sufficient to separate this case from the typical first party insurance case?
And the answer to that question is because you could find those sorts of details in literally any case.
Is that testimony in the record? Or in other words, could the trial court have accepted that testimony as unique to this case? Was that something that was in the trial court's discretion to do?
And that's where I think the answer to that question is no, that we still have a standard review of what's competent, substantial evidence, not just any evidence, right? And pointing to the fact that a motion to consolidate was filed and denied, in our knowledge as jurists, that doesn't make this case interesting or different or difficult. And particularly when we look at the multiplier, right? Because multiplier, you look at the front end, you look at At the time the lawyer takes the case, not what happens subsequent to the case. That goes to the row factors, not to the quantity factors. And so at the time Mr. Woodward took this case, he'd spent a grand total of 1.2 hours, if we were to accept that time in the timesheets, with the Colognes. Signed him up on the spot, that was it. Referred to him by a public adjuster that he's done business with before. If that is enough to substantiate a multiplier, then again, any case is. And that's where we have to have our competent substantial evidence, where there's none. So any lawyer can come up with something. Oh, what did they come up with? They came up with that Mr. Colognes speaks Spanish. I, first of all, was sort of shocked by that argument. There's equal protection issues there, but this is Osceola County. 55% of Osceola County is Hispanic. How does that possibly, that factor, how can that move the needle on a multiplier analysis? And then, well, there was a prior claim. If that's enough, then literally anything's enough. And that's always been my concern since the first day I read Joyce, was that basically this means if you accept that case, I was afraid that it would mean that we can never reverse multipliers. Now, I've been wrong about that, though. We saw from the 4th DCA in that Deshfandy case again, where they said, no, that there still must be competent substantial evidence, and it wasn't there in that case. And I don't think it's there in this case. So I don't think there's enough. Even 1.25 multiplier, that's still $15,000, right? That's a lot of money that just falls out of the sky for Mr. Woodward, because we know that he was going to accept this case. We know that all the lawyers that do this stuff take these cases left and right, because you have a prior payment, you know it's going to settle. And it's the threat of these fee hearings where the leverage that comes into play with this. It's easy to forget. Stillwater has to pay our firm, Mr. Rock, and Mr. Danahy, pending my next
certainly
argument.
how we, as the 5th DCA, not the Florida Supreme Court, not the legislature, though, apply those sorts of policy arguments to this case. It seems like there could be simpler cases than this one, potentially. And so if we're operating under the structure that we are now, what is it? Is it just that these issues could have arisen in any case, so therefore no multiplier is appropriate as a matter of law?
Well, again, I think in this case, we have 1.2 hours of time for which Mr. Woodward could find all of the factors for a multiplier, because that's when we have to look at it. Once the case is accepted, anything that happens subsequent to that does not impact the multiplier. And the only thing I saw in this case, in this record, is that we have a Spanish-speaking plaintiff who also had I think a prior roof claim. And if that's enough, then
my angst here is, okay, you cite to Justice Kennedy, I don't know if he was the Chief Justice, you cite to him repeatedly there, and that obviously Justice Kennedy, joined by Justice Lawson, had a view about whether multipliers are even a good idea anymore. But that's their decision to make. I mean, I'm trying to, Joyce, if I recall, was a first party property claim too. And in that case, it was the adjuster initially denied the claim. The lawyer got involved and said, no, it is a covered claim. We'll pay it. And that went from a $38,000 fee just for that. I mean, barely involved in litigation, to a 2.0 multiplier, turned into a $76,000 fee. Obviously, Cohen and I don't remember who else was on the panel, thought that was something that we didn't agree with.
Judge
Supreme
Jordan
Court disagreed with that and made it pretty clear why they disagreed with us. And I'm trying to figure out if a 2.0 in Joyce and a first party claim was okay with the Supreme Court under the facts, and I don't remember all the facts, it's been a while. How do we find the abuse here at a 1.25 when there was more involved?
A couple things. First of all, and it was Judge Jordan, associate judge, was the third member of that panel. And I had that case from the time it filed the answer all the way up. And that case was different. What happened there was there's a material misrep that on the insurance form, it said, have you ever had a prior loss the past 3 years? And the form that Federated got said no. It turned out that the agent, we took his deposition, the case settled that day. The agent was a young kid, and he came in and said, oh yeah, I remember the guy telling me about the flood they had last month. And they had the form in the office where they checked yes, and he just typed it in wrong. So once we figured that out, it went from a complete claim denial to honor the claim. And so it was different than this case. But nonetheless, to answer your Honor's question, yes, I did take some liberties quoting from the dissent in Joyce. And part of that is the hope that maybe this court will recognize that I think if the Supreme Court were to review Joyce and its rationale today with 4 more years of experience, that perhaps they might indeed revisit this entire jurisprudence. This court, of course, could certify a question to that effect. That's the only way I could get there, because, like I concede, I do read Joyce to basically say that you can almost never reverse these things anymore. Though disfandy is a change from that. Fourth District said no, there still is that standard. But yes, obviously the Joyce standard makes it reversal much more difficult than it would have been in 2016. Of course, I will say that when we got that order accepting review, we knew that day that case was going to be reversed. I mean, it's just the way those things go. In any event, I hope my argument is clear with the multiplier. I still believe that if a multiplier is available here, it's available whenever a trial judge decides to do it, arbitrary or not, and that's what concerns me in a case like this. 1 hour meeting, there's no factors. That's the lens we must apply. The next issue, and perhaps final one, depending on how much time I have, is whether the fee experts' fees are taxable against Stillwater. And Mr. Danahy has decided not to participate today, but I think there is a bona fide conflict within this court. If we look at the Seminole County case from First Boyle Investments from '99, which is very clear following Palma, of course, a 627-428 case.
Are you questioning the amount of the fee or just the entitlement?
The ability to tax a fee expert against the opposing party.
Doesn't 92.2312 say any expert who shall have testified any cause shall be allowed a witness fee?
The difference, though, is we're dealing with a fee expert, and this court has specifically said that taxing a fee expert against the defense is reversible error. And that's the Boyle investment case. It cites De Palma for that proposition. And then we have the Fourth District, I believe.
So everybody that the plaintiff would call in this scenario to testify, because they have to put on testimony for a fee, right?
They do.
All right. So plaintiff says, well, we need to have somebody testify on our behalf as to what a reasonable fee is. And that person is going to spend their time as an expert getting ready to do whatever. And he or she is not entitled to a fee to be taxed. It's something that the winning party has to pay their expert.
And again, we look at what this court says, that the answer to that question is yes. And we go back to 1985 when Roe was published. We look at I think it's pronounced Treviso case, which I guess long before I was practicing, I was an infant, that lawyers would offer fee expert testimony gratuitously, routinely, as a professional courtesy. The Supreme Court said that. And obviously the environment has changed dramatically in the past 35 some odd years. That now
Treviso says it can be taxed now, right?
No, it says under very limited circumstances, which again, this court said when you're dealing with fee experts, they're not taxable. And the Fourth District has said that as well. The only time it hasn't said that was 2 years ago with the Smith versus Unum case, which only followed Winter Park Imports, which is dealing with expert taxability with your standard merits experts, not fee experts. So this court has specifically said when it comes to fee experts that fee only benefits the lawyer, and therefore it's not taxable to the defense. I see I have 5 seconds left. My final point, though I won't be able to discuss it, is the prejudgment interest was miscalculated ministerially. So that's just a ministerial error, which I don't think they're even challenging.
They say it's waived.
They did, and
that's the argument you're presenting now was not the argument you presented to the trial court, and the trial court, I guess, adopted your argument, and
the trial court, and I'm out of time, but the trial court got it wrong. I suggested another erroneous way, admittedly, of calculating it, given all the things I was putting together with the post-hearing materials, and they actually said the right way to do it, of all ironies. And the judge just denied the motion. So it was before his honor. It's again ministerial act. So I think the fact that I pointed out is enough to preserve it under the circumstances of the ministerial error. Nonetheless, that is the final point. So unless there's further questions, I do appreciate the court's time and attention to this case. Thank you very much.
Okay, thank you. All right, Mr. Hauser, you have 8:49 according to the clock.
Do I get the 49 seconds that Mr. Angel got? I'm just teasing.
Why don't you just go ahead and argue and we'll see how it goes.
Okay, thank you very much, Judge. As to the issue of the expert witness, I think that argument is frivolous. And the reason it is frivolous is that all the courts, number one, you have to present an expert attorney's fees witness. Number two, this court has ruled in Smith v. Ullman Life Insurance Company that an expert witness must be compensated. Number three, all those cases were eminent domain cases, and the law in eminent domain is different than the law is in 627.428 and or 57.041. As to the multiplier, in this particular case, at the time that Mr. Woodward took the case, two independent adjusters had ruled that it was caused by wear and tear that would not have been compensated, that would not have allowed Mr. Colon to recover his under the insurance policy. He was required to give an exam under oath, which indicated that the insurance company thought there was fraud, and Mr. Colon's attorney had reason to believe this was going to be a very, very difficult case. Remember, I think the defendant had like 17 different affirmative defenses. The defendant had 24 witnesses on the witness list, of which Mr. Woodward had to depose 12. But I want to go back to a number of the arguments made by opposing counsel. The court cannot follow the federal court cases because the Florida Supreme Court has specifically rejected the federal way of calculating attorney's fees. They rejected it in Florida Patients Compensation Fund v. Roe. They rejected it in Quanstrom. They rejected it in State Farm v. Palmer as to whether or not you can get attorney's fees for litigating the amount of attorney's fees. And they rejected it in Joyce versus Federated. So that whole federal argument is simply not applicable under the Florida law. Again, they failed in their burden as to what specific hours were excessive. Mr. Rock never testified to it. His time records reducing the number of hours was never introduced into evidence. All we're asking is that this be remanded back to the trial court to explain the following. Number one, what was the reason you reduced it for 60 hours, 60%? Please give us the specificity to allow the appellate court to be able to review this properly. Number two, how in God's name did Mr. Colon litigate on a level playing field if you're limiting his number of hours to 135 hours, whereas Stillwater incurred 246 hours? In fact, that number is even more. The number of hours proffered by plaintiff's expert witness was 253.4, which is almost virtually identical to the 246 spent by the other side. How in God's name can you be on a level playing field? And all we're asking at this stage is for the court to explain its reasoning. Now we are asking, or I am asking, that you direct the trial court not to consider Mr. Rock's testimony at trial as to the reduction of the number of hours, because Mr. Rock's testimony was purely general in nature and not specific. And the opposing counsel has cited the Universal Property versus Desparty case. That's found at 314 7th 3rd 416. That case actually supports our position, because in that particular case, the plaintiff's attorney, in general terms, said that the attorney's fees should be reduced by 10%. The defendant's attorney did a line-by-line analysis in Universal and came up with 110 hours. And the third DCA literally struck the plaintiff's expert's testimony for failing to do a line-by-line analysis. And that's what happened in this case. In our case, although Mr. Rock may have done it, it was never introduced into evidence. And because it was never introduced into evidence, the trial court could not consider it as a fact finder of the hearing itself. As to the issue of the interest, I think it was waived. Let me see what else I've got.
We send this back, remand this for the trial court to make specific findings on the reduction of hours. Shouldn't we also reverse the multiplier and remand it with instructions to make specific findings on the constant factors?
No court has ever ruled that way. Mr. Stillwater has never cited a case that has held that. The record is absolutely replete with evidence to show that there were sufficient facts to warrant a minimal, I repeat, minimal multiplier of 1.25%. Remember, the expert for the plaintiff said 200% was reasonable. So the answer is no. Unlike the reduction of the number of hours, there has been no district that has ever reduced a multiplier for not stating with specificity where the evidence shows that there was sufficient evidence presented. Any other questions?
Thank you. I don't-
I want to use my 2 minutes for something, but I can't think of what. I want to thank the court. I think this is a very simple case. This is a lack of evidence case where the plaintiff failed to sustain the insurance company failed to sustain its burden of proof because it failed to, in some ways I'm blaming Judge Murphy. I'm really not. It's really Stillwater's fault. They failed to explain to the court with specificity, other than the trial transcript of the cross-examination of Mr. Woodward. They failed to state with specificity what the hours should be that are reduced. And because they failed to meet their burden, there is no question that this case must be reversed.
Okay. All right, counsel. Thank you. We'll take it under advisement.